Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi
My name is Izzuddin. So on behalf of AMAL Fund and KUM Melbourne, I would like to welcome all of you to today's talk. Inshallah, this will be the first of many other talks to come. Today's topic will be on making a will or Wasiyah in Australia. And our guest speaker today is Brother Rahman. Brother Rahman is a former lawyer from Singapore, and currently he's a full-time lecturer at the College of Law and Justice in Victoria Uni. And today he will give us some insights on the importance of making a will in Australia and also the legalities around the topic. At the end of the talk, we will open the floor for Q&A. And if you have any questions, we're more than happy to answer them at the end of the talk. If you have any questions that you want to put forward, please unmute yourself, or you can also use the chat to type your questions, and inshallah we will answer them. With that being said, I would like to invite Brother Rahman to start his presentation. Thank you.
First, say shukr to Allah that we are able to gather today in this on this occasion to remember him. It is part of our dhikr, and may the angels, may the malaika come and gather around us as we gather, even though it's online and not physically, inshallah, and carry the news back to Allah subhanahu wa ta'ala. Secondly, I'd like to thank the organizers, in particular AMAL Community Fund, for giving me this opportunity to share a little bit of knowledge, what little I know about this area of law. I was practicing in Singapore. I was in general practice in Singapore as a lawyer, and quite a bit of my practice involved the Sharia court. When I came to Australia, I also got admitted to practice in Australia, and I practiced for a while as part of my teaching when I was at Monash University. I'm now with Victoria University, and I'm now a full-time teacher. So I'm not in practice. I'm not a practitioner, although I am a quiet lawyer in both Singapore and Australia. So for today's discussion, what I'd like to do is go through what has been stated in the flyer, and that is basically why we encourage to make a will in Australia. What are the legal requirements for making a will, and what happens if you do not make a will? What happens to your wealth? How does it get distributed? That last part is a bit complex. I will not go very much into it, except to say that the distribution will be very different than if it were to be distributed according to Islamic law under Faraid. And I'll just give a couple of examples in my presentation. So if I may, I would like to start. I prepared some slides for our discussion today, so I'll share my screen. Can I share my screen, is it?
Yes, I think you have a co-host.
Yep.
Oh yeah, okay.
Function, yeah.
Okay, yeah, I got it. Thank you very much. So, now if anyone wants to ask any questions, please feel free to stop me. You can, I would rather that you do not put a message on the chat because that can be a bit distracting and I might not see your message until I've moved on. So I would prefer if you use the feature where you put up a hand and then I'll stop and I will respond to your question. Okay, so making a will or a wasiyah in Australia. First of all, allow me to explain some of the terminology because otherwise you may not be able to follow what I'm saying. So when I use the term testator, or sometimes nowadays because of plain language, people prefer to use the term will maker. That refers to a person who makes a will. And when I use the term estate, that means in the context of our discussion today, although it's got other meanings, but in the context of our discussion today, estate means the sum of the assets left by the testator, in other words, left by the person who made the will upon that person's death. That means the collective sum of that person's assets or property is known as the estate. Then the term beneficiary or heir. There is actually a slight difference in meaning in these two terms, but for our purposes, we can consider these two terms as synonymous. So a beneficiary or an heir is a person who benefits from a will or from the estate of the testator by law. And then you may come across the term executor or administrator or personal representatives. They all mean the same thing, and that is basically those terms refer to a person who is responsible for administering the estate of the deceased person. Now you'll also come across the term trust. Uh, the term trust in our context is a legal concept. It basically means is the legal responsibility which is imposed by law over the estate, over the assets of the deceased person. So in connection with that, when you come across the word trustee, that means it is the person who is responsible for administering the trust over the estate. In practice, that person, the trustee, is also the executor or the administrator or the personal representatives of the estate. Um, before I go one more, when we use the term executor, we are talking about a person who is responsible for administering the will under a valid will. When we use the term administrator, we are talking about a person who's responsible for administering the estate because there is no will left behind by the deceased, or there was a will but the will has been declared invalid. So then the proper term is administrator. The term personal representatives refers to both. So sometimes it may be more convenient rather than referring to someone as the executor or the administrator. If, for example, you're not sure whether the will is valid, then you can simply refer to the person as the personal representative of the estate of the deceased. And then finally, you may come across the term intestacy or intestate. It simply means a state or a condition of a person who did not leave behind a will, or the person did make a will, but the will has been found to be invalid. What happens is that if a person dies intestate, that means the person dies without leaving a will, or the person did make a will, but the will is found to be invalid, then what we call the intestacy rules apply, where the law actually sets out who gets what, how the estate of the deceased person is to be distributed, and there is a certain formula involved in distributing the estate of the deceased. So, what is a will or what is a wasiyah? In our context, a will or wasiyah is a legal document that states the intention or the wishes of the testator. So remember, the testator is the person who makes a will with regard to who should be responsible for a number of things. For example, who should be responsible for the funeral arrangements of the testator? Who should be responsible for settling the testator's debts? Now, this doesn't mean the person who is responsible for doing this must pay out of his own pocket. No, but the person is responsible to, as far as possible, to make sure whatever debts that the testator owed at the time of death is settled. Who should be responsible for distributing the estate of the testator? So you may be aware that after settling, inshallah, in most cases, after settling whatever debts the testator owes at the time of his or her death, there will be a balance or a residue. The legal term for it is a residue. There is a balance to be distributed to the beneficiaries of the testator. And then if there are minor children who will stand to benefit from the estate of the testator, who should be responsible for the minor beneficiaries and their shares. And the whole idea is that you make a will because a will is supposed to clearly show the wishes of the deceased person, which should, as far as possible, be respected. So what are the functions of a will? Well, a will is supposed to provide for the appointment of the executor or the trustee. In other words, a will is supposed to persons, because you can have more than one who is supposed to be the executor of the will. So when a person is performing the function of carrying out the will, person is executor. But as I mentioned earlier, by law, a trust is created over the estate of the testator. So in distributing the assets of the testator, the executor will be functioning as a trustee, but it's the same person. It's just a different function because of the different legal concepts which applies to the situation. If there are minor children, then a will or a wasiyah is also a way of providing for who should be the guardian over the minor children. Now, by law, if the testator was married and leaves behind a spouse, then the spouse will be the natural guardian over the minor children. But sometimes there may be a dispute, or sometimes it could be that during the life of the testator, the children were being looked after by, say, the grandparents, or by their uncle or by their aunt. And the testator may prefer that the persons who have been looking after the children continue, even though the children may have another parent who is still living. It could be because the testator was separated or estranged from the other parent, and the children are placed in the care of a relative, and the testator prefers that same relative continue to look after the children. The manner of the funeral, in other words, how the funeral should be conducted, because people may have preferences and they may want to specify their preferences as to how the funeral should be conducted. And then, of course, a will is supposed to provide for the administration of the estate. In other words, to settle the debts that the testator owed at the time of his or her death, to invest assets if it is specified, if that is what the testator wanted. And this becomes important if there are minor children. In other words, there are minor beneficiaries, then the testator may want certain assets to be invested for the future of the children until they come of age and they can decide what they want to do with their respective shares. And then, of course, to distribute the residue or the balance of the estate to the beneficiaries. Why is making a will encouraged? Very simply, it is because to make clear the intentions or the wishes of the deceased person. And the whole idea is to avoid any possible disputes over who has the right to administer the estate. If you do not make a will, or if you make a will, but for some reason you do not appoint an executor, then there may be a dispute between the family members who should have the prior right to be the administrator or to be the trustee of the estate left behind by the deceased. So if you make a will and you specify a particular person to be the executor, then it helps to eliminate, or at least it helps to reduce the scope of any possible dispute. Also, it helps to avoid possible disputes over funeral arrangements. And perhaps most importantly, avoid possible disputes over the distribution of the estate or the wishes of the deceased as to how his or her estate should be distributed. For Muslims, this is qualified by the Islamic law on inheritance, on Faraid, and we'll have a quick look at that afterwards. Another reason is there is no provision in Australia for Islamic law of inheritance or Faraid to apply if a person dies intestate. So remember, intestate means the person dies without leaving a will, or the person had made a will, but the will has been found to be invalid. Because if a person dies intestate, then the distribution of the estate of that person will be according to state law, which we will see from a simple example is very different from distribution according to Faraid. So, under Faraid, the distribution to the family, distribution of a deceased person's estate is primarily focused on the family members, including the parents, if the parents outlive the deceased, of the deceased. The shares of the heirs or the beneficiaries under Faraid are fixed. They are stated in the Holy Quran, and the shares depend on who survives the deceased, whether they are male or female or both, and whether the deceased was married at the time that the deceased passed away. What is important to note is that in Islamic law, we are not allowed to increase or to diminish the shares of our family members by making a will. Now, this is where there is a possible dispute. We may make a will specifying that we want our estate to be distributed according to Islamic law, which is very different from distribution according to Australian law, or I should say specifically according to Victorian law, because the rules of distribution for intestacy, there are differences between states. So the rules of distribution in Victoria may be different from the rules of distribution in another state of Australia. And the dispute might arise because a family member might prefer the distribution to be according to Australian law or Victorian law rather than Islamic law. Now, having said that, we are allowed to give away up to 1/3 of our estate by will to charity or to a person who would not normally inherit. In other words, we can give up to 1/3 of our assets to someone who, under Islamic law, will not normally have a share in our estate. Excuse me. For example, an adopted child. Now, I use the term adopted child loosely because in Islamic law, or rather I should say, Islamic law doesn't recognize adoption. So even though you may adopt a person legally under the civil law, but under Islamic law, that child, the adoption is not recognized. That child may be treated as a foster child. And that child will not normally inherit from the estate of the foster father or the foster mother. So this is one example. You can give away up to 1/3 of your estate to someone who would not normally inherit from your estate according to Faraid or under Islamic law. The rest must be distributed to your family members, and you cannot increase or decrease the shares of a particular member. Now, how it is calculated is a complex. it's it's an Islamic science called mirath, and it is a complex. There are complex calculations involved depending on who survives the testator. I'll just use a simple example, and this example is based on the trial calculation by the Sharia Court of Singapore. The Sharia Court of Singapore has, on its website, has got a calculator where you enter information regarding your family members, whether your parents survive you, whether your parents are still alive at the time that you intend to make the will, whether you are married and your spouse is still alive, how many children do you have, how many, and among your children, how many boys and how many girls. And when you input that information, the calculator will provide what they call a trial calculation of the shares that will go to your family members if you happen to pass away at that point in time. Okay, so a simple example, let's say the deceased was a male person and was survived by both his parents. Both his mother and father are still alive when he passed away. He had one brother, he had one sister, he was married, he had one son and one daughter. So his estate will be divided into 72 shares. His brother and sister will be excluded because since his father is still alive and he also has a son, these two male members of his family will exclude other members of his family apart from his wife and his mother and his children. I should mention at this stage that Islamic law is such that you will always look for a male member of the family of the deceased. It starts with father, husband, son. In the absence of all these three people, then you will look for the brother of the deceased or an uncle. His parents will be entitled to 1/6 each. So out of the 72 shares, each parent will get 12 shares. His wife will get 1/8. That's 9 shares out of 72 shares. And then the remaining 39 shares will be divided into 3 parts. The son will get 2 parts, so 26 out of 72 shares, and the daughter will get 1 part, that is 13 out of 72 shares. Now, I think you can see that the number of shares and the fractions will change depending on who survives the deceased person. So that's what I mean by the calculation is quite complex, and this is just a simple example. Now, what about inheritance under state law? Under state law, a testator may, by will, exclude his or her family members from sharing in the estate of the testator. Of course, this is subject to adjustment by the court in certain circumstances, and I'll come to that in a later slide. But generally speaking, you can exclude your family members. So for example, you may exclude your parents, you may exclude your son, if you are using the same example. So you're a male person, you want to make a will according to state law, according to Victorian law. You can exclude your parents, you can exclude your son, you can divide your estate equally between your wife and your daughter. So as you can see, it's very different from Islamic law. This is not permissible. You are not allowed to try to exclude your family members who have given specific shares in your estate by Islamic law. And this law is actually set out in the Holy Quran itself, and not just something developed by Islamic scholars. What happens if you die without a will, or you make a will but the will be invalid? Then the distribution according to rules of intestacy under Victorian law, just to give you an example, is also quite complex. So I won't go into detail, but I'll give you an example. The de facto partner of the deceased has rights to the estate of the deceased. And the de facto partner has priority over the parents of the deceased. And even if the deceased was still married at the time of his or her death, let's say, for example, the deceased was still legally married but was estranged, separated from the deceased lawful spouse, and living with someone else in a de facto relationship, and that other person can establish that he or she was in a de facto relationship with the deceased, then that de facto partner still has rights. Generally speaking, the partner and the partner and the spouse of the deceased will share equally in the estate of the deceased. So you can see it's very different from distribution under Faraid. So what are the legal requirements for making a will? In Victoria, now remember I mentioned that the rules of intestacy are different from state to state. So as far as the legal requirements are concerned, there are also slight differences. So I'm only talking about the legal requirements for making a will in Victoria. The will must be in writing. It is preferable and recommended, but it doesn't have to be in English. It must be witnessed by 2 witnesses, and has to be done in this way. The testator, the person making the will, and each witness must sign in the presence of each other, but the 2 witnesses do not have to sign in each other's presence. In other words, the testator can sign the will in front of the witnesses, front of one witness, will in front of the other witness. The that particular witness will sign the will in the another witness separately, then that witness, the testator signing the witness must sign presence of the testator. Okay, so as you can see, it is preferable that all three, the testator and two witnesses, sign in each other's presence, having to sign twice if the witness separately. The testator must be of sound mind and be free from influence. A witness may be but should not be a beneficiary. There's a very simple, pragmatic reason for this. If you are witnessing a will and you are also a beneficiary under the will, you may be inviting challenges from somebody else who may not be happy with the influence into giving share or into giving you a bigger share than what you should be getting. If the witness are disinterested to gain anything from the will, then it is difficult for someone to mount that kind of challenge. So you can be a witness if you are also a beneficiary, but it is recommended that you should not be a witness if you stand to gain from the will. And importantly, the distribution of the estate must be clear and must be certain. I'll give you a simple example. You may wish to leave part of your estate to Halam Masjid. If you simply say, I leave 1/4 of my estate to Halam Masjid, it may be invalid because in law, Halam Masjid does not have a legal existence. As an entity, Halam Masjid doesn't exist. Halam Masjid is run by IWAD, Islamic Education and Welfare Association of Dandenong. So if you want to leave part of your estate to Halam Masjid, then you should leave it to IWAD. And because IWAD is an incorporated association, it exists in its own right. It has got a legal existence. In other words, it is a legal person, even though it is an artificial concept, but it is a legal person. It can sue, it can be sued, it can receive gifts, and it can give gifts to people. Halam Masjid in Australian law doesn't exist in its own right. It doesn't have its own legal existence. Okay, so that's one example where you have to be clear, and you have to be clear who you want to leave your estate to, and the will must be, the terms of the distribution in the will must be certain. So whether it is an executor or somebody else responsible for distributing that money or who to give that asset to, now I mentioned example is where the testator and a witness did not sign initials. I think there is a message. My internet connection is not very stable. It does fluctuate. So I can see that is happened, I think, 2 or 3 times already, where it might have. Or another way to challenge a will is to say that, well, the testator was not of sound mind, health problem. He didn't know what he was doing. Or he was under undue influence. He was being pressured, or he was being swayed by a particular person into making the will and specifying the distribution that is specified in the will. So in other words, the testator at the time of making the will did not make the will freely, did not make the will voluntarily. There was some kind of pressure or influence upon him, or he or she was simply not in the proper frame of mind to make a will. Now, that is for wills that may have not been properly executed, or the circumstances surrounding the making of the will may be in some doubt. A will that has been validly executed, in other words, it was done properly, there's no question whether the testator was of sound mind, the testator was of sound mind, no question of any undue influence or any pressure from anyone. Nevertheless, such a will, even though the will is valid, may still be challenged in certain circumstances. One simple example might be, say, the testator was bedridden for the last 10 years of his or her life. The testator had several children, let's say one daughter and several sons. The testator's only daughter sacrificed her career to devote herself to caring for the testator. Sons progressed in their careers and had the opportunity to accumulate wealth. So because the daughter gave up her career, she had to forego her promotion prospects. She had to forego opportunities to accumulate wealth in order to look after the testator, maybe the father or the mother. And yet the testator divided the estate among the children equally. The daughter may apply to the court to adjust her share, to take into account her contributions towards the testator. If you think about it, it's only fair, right? She sacrificed her career. She did not have the opportunity to accumulate as much wealth for herself as her brothers did. The brothers progressed in their career, they accumulated wealth, and yet the testator divided the estate among all the equally. So in that sense, it is fair to the daughter. So the daughter may apply to the court to adjust the distribution to give her a bigger share compared to her brothers, to take into account her contributions towards the testator. This is what is known as a testamentary family maintenance provision, or application, or for short, a TFM application, a testator's family maintenance application. The rationale behind it is that in making the will, the testator has failed to take into account one of the beneficiaries. Internet connection is is unstable. Right. And to share that reminder with you, in Surah An-Nisa, Allah commands you as regards your children's inheritance to divide the inheritance the male, a portion as ordained by Allah, and Allah is ever the all-knower and the all-wise. In Ayah 13, these are the limits set by Allah, or ordainments as regards the laws of inheritance, and whosoever obeys Allah and His Messenger Muhammad sallallahu alaihi wasallam will be admitted to Jannah, to abide therein, and there will be great success. And whosoever disobeys Allah and His Messenger Muhammad sallallahu alaihi wasallam and transgresses the limit set by Allah, Allah will cast him into the fire to abide therein, and he or she shall have a disgraceful torment. So that concludes my presentation. Shukran jazakallah khair wa billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.